Chapter 23. Injunctions against Trespass. Analysis. Section 1907. Section 493. Nature of the jurisdiction. The term trespass as used in equity differs from waste in respect to the privity of title between the plaintiff and the defendant, and in respect to the rightfulness of the defendant's possession of the land, which two facts constitute the technical requisites of waste. It differs from trespass in law in that it does not require that plaintiff be either entitled to, or actually in, possession, but includes also cases in which plaintiff's action at law would be on the case or in ejectment. At an early day the Court of Chancery refused to interfere and restrain any trespasser. Lord Thurlow broke through this rule, and began to use the preventive relief against such wrongs. He was followed by Lord Eldon, and the jurisdiction is now firmly established in its principles, although there is no little disagreement among the courts, and especially the American courts, in applying these principles. The ultimate criterion by which the jurisdiction is determined is the inadequacy of the legal remedy, but this the cases prove to be a somewhat flexible standard. The ideal remedy in any perfect system of administering justice would be that which absolutely precludes the commission of a wrong, not that which awards punishment or satisfaction for a wrong after it is committed. Tried by this test all legal remedies are inadequate, and if adequacy of legal remedy were used in this sense by courts of equity they would enjoin any and all threatened trespasses, however trivial, whether to realty or to personalty, a length, it is hardly necessary to say, to which they have never gone. Section 1908. Section 494, Extent of the jurisdiction. Instead, the equity courts have marked the limits of their jurisdiction far short of this. Trespasses to personalty are not enjoined at all, in general, on the ground that for a trespass, even one so serious as to amount to complete destruction, the damages which a jury will award are an adequate remedy. And the same thing is true of trespasses to realty when they consist of single acts or of occasional acts which are temporary in their nature and effect, and which are of such nature that damages as estimated by a jury will be adequate reparation. On the other side, speaking now affirmatively of the many cases in which trespasses to realty are enjoined, they can be divided into the following four classes. 1. The legal remedy is inadequate because the injury is irreparable in its nature. 2. The legal remedy is inadequate because the trespass is continuous, or because repeated acts of wrong are done or threatened, although each of these acts, taken by itself, is not destructive. 3. The legal remedy is inadequate because the defendant is insolvent. 4. The legal remedy is inadequate in a miscellaneous class of cases because the courts of law for one reason or another cannot give any or, at best, not accurately estimated or sufficient damages, though damages would be a perfectly adequate kind of remedy. The four classes will be discussed in order. Section 1909, Section 495, Irreparable injury. The term irreparable has been often defined by the courts in varying language. It is believed that the characteristics which the courts should seek as certainly marking an injury as irreparable, and which the majority of the decisions show to be its essential features, are, 1. That the injury is an act which is a serious change of, or is destructive to, the property it affects either physically or in the character in which it has been held and enjoyed. 2. That the property must have some peculiar quality or use such that its pecuniary value, as estimated by a jury, will not fairly recompense the owner for the loss of it. In the application of this test, however, there are many conflicting decisions. Thus, some courts treat land as per se property of peculiar value and will enjoin destructive trespasses to its substance without regard to the question whether, in the particular case, it really does have any peculiar value or not. By these courts it is made a subject for protection by injunction, just as in cases of contract it is a subject for specific performance without reference to its quality, use or value. Other courts, however, in similar cases, have taken the attitude that the question, whether an injury is irreparable or not, is an open matter of fact to be inquired into in every case, and have refused injunctions against destructive trespasses because the value of the land injured was small, and it had no peculiar use or quality for the owner. So, too, in the case of mining, the courts have sometimes applied the test of irreparability to the particular case, and finding that the owner had no use for the land beyond getting its value from it in the shape of minerals, have refused to grant the injunction when the defendant was solvent, and thus was able to give the legal relief of damages, although in England, and generally in America, mining is a form of trespass that is generally considered as irreparable, and, as such, is enjoined. Two and the same thing may be said of the cutting of or destruction of timber. These conflicts in the cases thus result, not so much from different views of what constitutes an irreparable injury, as an original question, as from a different practice with reference to distributing certain cases of the same general character in subject matter, into fixed groups that shall be considered as per se cases of irreparable injury. As a further source of conflict, there are a number of cases which, when dealing with trespasses to real property, tend to give to the term irreparable an enlarged signification, and make it virtually synonymous with serious injury. There are, of course, no particular classes of cases to which irreparable injuries are confined. Other illustrations are collected in the note. Section 1910, Section 496. Continuous or repeated trespasses. The jurisdiction of equity to restrain continuous or repeated trespasses rests on the ground of avoiding a repetition of similar actions. It is a basis of jurisdiction that is frequently found in cases where the injury is also irreparable. Very often, indeed, the injury is irreparable only because it is continuous or repeated, when it would not be if temporary. And in such cases the injunction will issue as a matter of course. For the further discussion of this subject, it will be convenient to consider, first, the cases in which the injury is the result of a single act, or set of acts, of the defendant, which afterwards operate by virtue of natural laws to produce the injury, and, second, the cases in which there are several or many acts of the defendant or defendants which give rise to as many different causes of actions. The distinction is roughly that between continuing and repeated trespasses, and is based on the distinctions made in the cases themselves. If a trespass is of the first class and produces substantial damage to the plaintiff, the authorities are well agreed that a proper case for an injunction is presented. If, however, the injury is little or nothing more than the technical invasion of plaintiff's legal right without substantial damage, there is a division among the courts, though a majority of the decisions show that the foundation principle of this branch of the jurisdiction fairly includes all such cases, whether the damage is substantial or not. If plaintiff's legal remedy may be vexatious, harassing, and hence inadequate when he recovers substantial damages, still more would it seem to be so when his recovery is only nominal. When the trespasses complained of are caused by the separate acts of individuals, a multiplicity of suits may be caused to plaintiff either because the defendants are numerous or because a single defendant does the same or similar acts repeatedly. The principle involved in all such cases is the same, and injunctions should issue. And when the basis of the multiplicity of suits which plaintiff fears is that the defendants are numerous, all authorities agree in granting the injunctions. But when it is the case of a single defendant who, by repeating his acts of trespass, makes it necessary for plaintiff to pursue his legal remedy only by a succession of actions, the decisions are curiously diverse. It is held, in a small group of cases, that this is not the kind of multiplicity of suits which equity enjoins, but that instead an injunction is proper only when different persons assail plaintiff's right. The other view, and the one sustained alike by the weight of authority and by principle, is that if a defendant manifests a purpose to persist in perpetrating his unlawful acts, the vexation, expense and trouble of prosecuting the actions at law make the legal remedy inadequate, and justify a plaintiff in coming into equity for an injunction. None of the cases show any tendency to make the seriousness of the damage the criterion, and the jurisdiction attaches as well to trespasses to personalty as to realty. Section 1911. Section 497. Insolvency of defendant. The inadequacy of legal remedies, ordinarily, against an insolvent trespasser is obvious, and the reason for equity's intervention in such cases is clear. The number of cases in which the defendant's insolvency is made a material part of the court's reason for granting an injunction is very great. The number of cases in which the question has arisen whether insolvency alone is enough to support an injunction is not so large, but is sufficient to show the general recognition by the courts of the glaring insufficiency of a judgment for damages against an insolvent. When, However, the legal remedy is not rendered inadequate because of the defendant's insolvency, as when the desired relief is possession of the land which may be procured by the ordinary possessory action at law, the injunction will be refused. Section 1912. Section 498, Miscellaneous cases. Besides the three classes of cases just discussed, there are other cases which permit of no definite classification, but which, largely for that reason, show most clearly the comprehensive nature of equity jurisdiction to restrain trespasses. In one of the leading cases of this kind, the Supreme Court of the United States quoted as the criterion of the jurisdiction, "It is not enough that there is a remedy at law, it must be plain and adequate, or, in other words, as practical and efficient to the ends of justice, and its prompt administration, as the remedy in equity." Cases which illustrate this broad rule are collected in the note. Section 1913. Section 499, Eminent Domain. There is one class of cases in which an injunction will issue against a trespass without regard to the character of the act, viz., when property is taken or used by a defendant under the right of eminent domain without first complying with the prescribed formalities for ascertaining and making compensation. In such cases, the courts do not stop to inquire whether the value of the property to be taken was little or great, whether the injury to the complainant was great or small, but grant the injunction first, on the ground that the constitutional provision makes the payment of a properly ascertained compensation a condition precedent to the right to take, and that injunction is the only way to enforce this provision. The injunction granted in such cases may be an absolute one which forbids defendant further to trespass till after proper condemnation proceedings, or it may be so framed as to reach the same end as such proceedings would, and thus save a second legal action. Section 1914. Section 500. What plaintiff must allege? A plaintiff who asks for the aid of equity against trespass, must, of course, show a case to justify the extraordinary relief he seeks. Hence, he must show in his bill not only a legal wrong, but, further, why the legal remedy is not adequate. And it is not sufficient for this purpose that he merely allege an irreparable or a continuing trespass. He must set forth the facts from which the court may draw the inference that the legal remedy is not sufficient. Nor is it necessary that he should allege that the injury will be irreparable. The same reason which makes it necessary for him to set out the facts, makes it unnecessary for him to do more. Section 1915. Section 501. Threatened trespass. In the subject of trespasses elsewhere, the main function of an injunction is to preserve property from future injury. Courts will not, however, enjoin against a mere speculative or possible injury. Instead, a reasonable probability of the injury resulting must be shown. Hence, if defendant has neither done nor threatened any wrongful acts, and denies his intention to do the acts against which an injunction is sought, it will be refused. On the other hand, if plaintiff shows that defendant has threatened to do acts of the kind which equity enjoins, that is enough to rest his case upon. And threats may be purely verbal without any acts, or they may consist of acts from which the inference as to defendant's intention may be made. If, however, the wrongful act is done, and it is not accompanied by threats of repetition, and does not itself constitute a threat, the injunction will not issue, since, in such case, it is needless. Section 1916. Section 502. Dispute as to title, General Principles. The effect of a dispute as to title on the propriety of granting an injunction to a plaintiff who seeks to enjoin destructive acts of a defendant who, in turn, justifies on the ground that he is the owner of the land affected, has been much discussed by the courts, and a considerable difference of judicial opinion has resulted. The source of the difficulty was a dictum and a decision of Lord Eldon that when a plaintiff stated that the defendant claimed by an adverse title, he stated himself out of court, a statement of the law which, when taken absolutely, Lord Eldon himself disapproved, and which, after repeated expressions of disapproval, the English courts finally modified a half-century later. As will appear below, the great weight of American authority is also opposed to the rule thus unqualifiedly formulated. The reason that a dispute as to title should preclude the granting of an injunction permanently is that under such circumstances it is possible that title may be in the defendant. If he has the title, then he has a right to possession, and ought not to be precluded from acquiring it. But if the injunction stands, he is under a permanent judicial inhibition from in any wise meddling with the property. His right to litigate the title in an action at law should be preserved to him. In brief, one should not be finally enjoined from acts which may be wholly rightful and lawful. But on the other hand, it does not follow from this that the injunction should be wholly refused. There being a substantial dispute over the title, it is clear that the plaintiff may prove to be the owner, and his possible interest should be protected at once, because otherwise their injury may be committed before trial. Hence, a true regard for the interests of both parties requires that a temporary injunction should issue to preserve the property in its present condition till the ownership is decided. Such temporary injunction is of course subject to the usual governing principles of temporary injunctions, which are discussed elsewhere. Some of the more important of these principles in this connection are that, since the action of the court may wrong one party, whether it grant or refuse the injunction, the defendant is wronged by granting the injunction if he is the rightful owner, the plaintiff is wronged by refusing it if he proves title, the courts are largely guided in forming their conclusion by balancing these possible wrongs against each other, and acting unfavorably toward whichever party will be least injured by unfavorable action. A small degree of lackers will lose plaintiff his right to it. Its purpose is almost always to preserve the status quo. The prospective injury on which plaintiff must rest his case is that which will occur before he can have time to establish his right, not the full and entire injury on which his right to a permanent injunction may rest, and the injury to occur in this interval must be sufficient to support an injunction. Finally, its continuance or dissolution is dependent upon the outcome of the dispute as to title. It follows that when the sole basis of equity's jurisdiction is to prevent a multiplicity of suits caused by a continuing trespass or by repeated trespasses of a single individual, a temporary injunction will rarely, if ever, be appropriate. For it is the plaintiff's own fault if, during the interval while he is establishing his right, he brings a number of suits. He can afford to wait till the right is determined in his favor at least better than the defendant can afford to give up even temporarily the right to use the property, if it be his. Section 1917. Section 503. Defendant in possession enjoined from destructive acts. In the leading English case which discusses the effect of a dispute as to title on the granting of an injunction against trespass, the court, after an exhaustive review of the cases, made the following distinction: where a defendant is in possession, and a plaintiff claiming possession seeks to restrain him from committing acts similar to those here complained of, cutting timber, ornamental trees and shrubs, and sods, the court will not interfere unless, indeed, as in Neal v. Cripps, the acts amount to such flagrant instances of spoliation as to justify the court in departing from the general principle. But where the person in possession seeks to restrain one who claims by an adverse title, the tendency of the court will be to grant the injunction, at least when the acts either do or may tend to the destruction of the estate. A close analysis of the above passage may perhaps lead to the conclusion that the class of acts which will lead to an injunction in the one case usually will have the same effect in the other. Nevertheless, the distinction is one which cannot be disregarded in view of the state of authority, nor is it without reason. That reason, as given in the same case, is as follows. If a man claims to be owner of an estate of which he either is in possession, or in a position tantamount to that, the court will be very slow to interfere to restrain such an apparent owner from doing those acts which an owner so situated may properly do. There is a wide difference between such a case and that of a person claiming to be the owner, whatever the ground of his claim, not taking proceedings at law to recover, but coming on the owner's estate, and doing acts injurious to it. In other words, the fact of possession in the defendant is regarded as strong evidence of title in him, and the plaintiff must therefore make a stronger case to justify an interference with him. The logical effect of this reasoning is, that the plaintiff should be granted an injunction either if he produce stronger evidence of title than would otherwise be required of him, in order to offset the inference of title which defendant's possession raises, or if, as is suggested in the passage above cited, he show that defendant is committing flagrant instances of spoliation, that is, more than ordinarily destructive acts. The actual effect is that some courts either grant the injunction only in the latter case, or else lay down the hard and fast rule that no injunction will issue when the defendant is in possession under claim of title, till the plaintiff has established his ownership in an action brought for that purpose. The weight of authority, however, has now come to be that even in this case a temporary injunction will issue if, pending litigation, there will otherwise be such serious acts of trespass that damages will not be an adequate remedy. The reason which sustains this holding has never been more forcibly and clearly stated than in Duval v. Waters, one of the earliest American cases in which the question was considered, in which Chancellor Bland said, should it turn out that the defendant had an unquestionable title, then the granting of such an injunction could only operate temporarily and partially to the prejudice of the free exercise of his right of property. But on the other hand, if it should be eventually shown that the plaintiff had the title, then, as the injunction turns no one out of possession nor displaces anything, it must necessarily leave to the defendant the advantage of fighting the plaintiff with his own property, upon which, had not the injunction been granted, the most irretrievable destruction might have been perpetrated, acts of waste might have been committed which would deprive the plaintiff of the very substance of his inheritance, mischief might have been done which it would require years to repair, and things might have been torn away or destroyed which it would be difficult or impossible to restore in kind, such as the building, fixtures, trees, or other peculiarities about the estate, which a multitude of associated recollections had rendered precious to their owner, but as compensation for the loss of which, a jury would not give 1 cent beyond their mere value. Section 1918. Section 504. Defendant not enjoined from mere use. It is not to be inferred from the above that the courts which have gone thus far are at all hasty, or even ready, to enjoin one in possession claiming title. It has already been pointed out that the injunction granted is a temporary one, subject to all the restraints which the courts always throw about this exercise of their strong arm of equity. It is only acts for which there is no adequate legal remedy that will be thus enjoined. Hence, the courts never enjoin a defendant in possession from mere use of the premises. Pending an action for the possession, while the title is disputed and undetermined by a judgment at law, equity ought not to interfere to restrain the defendant from continuing the possession, from the ordinary and natural use of the premises, and the enjoyment of all benefits which flow from possession. If the premises be a farm, the defendant should not be restrained from cultivating the land and enjoying all the benefits which flow from the natural and ordinary use of a farm as a farm. To this end he should be permitted to sow and gather any ordinary crop upon the cultivated ground. He should be permitted to put up any temporary sheds or other buildings necessary for the protection of his stock or the preservation of his crops. He should be permitted to use all the usual agricultural implements in the cultivation of the broken land, not merely in the harvesting of crops as seems to be indicated by the restraining order, but also in planting and cultivation. He should be at liberty to pasture his stock on the grasslands, providing, at least, he has no more stock than is ordinarily raised and kept on such a farm. In short, he should be permitted to use the farm in any ordinary way, as such a farm is used, with the single limitation that he commit no waste, and make no substantial and injurious change in its condition, and in the determination of what is such use, the courts of a particular jurisdiction will, of course, act consistently with their own holding as to what constitutes irreparable injury. Hence, acts may in one jurisdiction be permitted as mere ordinary use which, in others, would be enjoined as destruction. Section 1919, Section 505, Plaintiff in possession. In view of what has been said above, and of the state of authority on the question of granting a temporary injunction against a defendant in possession claiming title, no argument or discussion will be necessary to show that when the plaintiff is in possession claiming title, he should be granted a temporary injunction, pending the litigation over title, against all trespasses, such that, from their nature or the surrounding circumstances, as, for example, the defendant's insolvency, he cannot have an adequate legal remedy for them. And this is the almost unanimous holding of the courts, though there is an occasional intimation that the mere existence of a dispute as to title is of itself, regardless of the state of possession, enough to preclude the granting of any injunction, temporary or permanent. Section 1920. Section 506. Establishment of title. The following language of the court in a leading American case is often quoted. Two conditions must concur to give equity, jurisdiction, over trespasses. The plaintiff's title must be admitted, or be established by a legal adjudication, and the threatened injury must be of such a nature as will cause irreparable damage. This language was used by the court in speaking of the granting of a permanent injunction, a fact not always noticed in quoting it, and from what has been said it follows that in this connection only is it true, and that it is to be so confined in its application. The suggestion of the court that the establishment of plaintiff's title must take place at law is not necessarily true, however. The general principle of equity, that having taken jurisdiction of a cause for one purpose it will retain it and give complete relief, makes it a proper proceeding for courts of equity, if they see fit, to investigate the title themselves at the hearing of the same suit in which the temporary injunction is granted, and then make permanent or dissolve the temporary injunction according to the result of the inquiry. Courts of equity, however, more usually send the question to be tried at law, but this is from reasons of policy rather than of jurisdiction. If the plaintiff's title is clear, though denied by the defendant, a permanent injunction may issue at once. If the court decides to have the question tried at law, it may procure diligence in the prosecution of the ejectment suit by framing an issue as an incident to its own proceedings and sending the parties to law with it, or by granting the temporary injunction to a plaintiff out of possession on terms that the injunction shall continue only if he begins and prosecutes his action of ejectment with diligence, or, if the defendant is the party out of possession, and therefore the proper person to bring ejectment, by a provision that the injunction shall be made permanent if he fail to do this within a reasonable time. Section 1921. Section 507, Possession. When given by injunction. The question has not infrequently come before the courts just how much relief, if any, is to be given a plaintiff out of possession against a defendant in possession. It has been shown that if the defendant is engaged in acts of a kind proper to invoke equity's preventive power against, he will be enjoined even when he claims title. A fortiori it is clear that the same thing should be true if he is admittedly a trespasser, and such is the law. In general this is the only relief that equity will give in such a case. The further relief which the plaintiff may desire is usually possession of the land. If this is asked for as part of the prayer of a bill for an injunction, it would be consistent with the general equitable rule of giving complete relief to award possession to the plaintiff in such a case. This course seems to be almost never followed, but instead the plaintiff must bring his action of ejectment at law. If possession alone is what plaintiff desires, he can get no relief in equity, because the legal remedy afforded by an action of ejectment or of forcible entry and detainer is adequate for the specific relief desired. And this is no less true, though the defendant is insolvent, or though plaintiff, if he had brought his bill sooner, might have secured an injunction against the destructive acts which accompanied the taking of possession by the defendant. Beyond the fact that the legal remedy is adequate, a further reason against transferring possession by injunction, when that is the only relief given, in this country is that it deprives the defendant of jury trial, and so is unconstitutional, and if the transfer is sought by a temporary injunction, an additional reason against it is that this is an attempt to use a temporary injunction for the purpose of changing the status quo, whereas its more usual and proper function is to preserve the status quo. But though the rule is general that possession will not be granted by injunction, it is subject to exceptions which exist because legal remedies in the particular cases fail or become insufficient. So, if the plaintiff's estate is purely equitable, and thus legal remedies are not open to him, he may be put in possession by a mandatory injunction. It has also been frequently held that one who has begun the process of acquiring title to public land according to the prescribed rules, but who has not yet acquired a title such that he can adequately enforce and protect his right to possession by legal remedies, may procure possession to which he is entitled by injunction. But his right to get an injunction ceases as soon as he has progressed far enough in acquiring title so that he can maintain ejectment. Another class of cases which has frequently led to a restoration of possession by injunction is that in which the defendant has erected a building which encroaches on the plaintiff's land. In such a case, three remedies are open to him. First, he may remove the building as far as it encroaches over the line, and then sue the defendant for the expense incurred. A remedy which is inadequate because it compels him to undo the wrong of another, because it compels him to advance the cost of men and machinery to effect the removal and take the risk of securing reimbursement from the defendant, and because it burdens him with the risk of injury to other portions of defendant's building not included within the encroaching part. Second, he may submit to the trespass and seek relief by actions for damages at intervals of time, a remedy the inadequacy of which is attested by the whole doctrine of injunction to prevent multiplicity of suits. Third, he may bring an action of ejectment, the judgment in which puts upon the sheriff in executing it the risk of injuring more of the building than is trespassing, so that this remedy, too, is an impracticable one. On the other hand, the remedy by injunction places the obligation to remove directly on the one who caused the structure to be erected. Hence, equity usually grants an injunction in such cases, and thus as a part of its relief restores possession of land to the owner. Section 1922. Section 508. The balance of injury. The state of facts which has just been considered often occurs in such form as to raise another question which courts of equity have had some difficulty in answering. If a defendant's building encroaches slightly on the plaintiff's land and the plaintiff's damage is small, while the cost to the defendant of removing it is great, should a court of equity disregard wholly the injury which granting relief to the plaintiff will cause the defendant, and issue the injunction? Or, should it balance the injury which its course will cause in granting or in withholding relief, and be influenced by this consideration in its decision? A further element is sometimes introduced into the case by the fact that the defendant is engaged in a business which serves public convenience, and thus can plead not only the injury to himself, but also to the public, as a reason for not granting the injunction. It should be premised in the beginning that the question cannot arise except in a case in which some sufficient reason for equity jurisdiction, such as irreparable injury or the prevention of a multiplicity of suits, exists. In other cases, the injunction will be refused on the simple ground that the legal remedy is adequate. It is believed, too, that the question of the convenience of the public should be treated as immaterial, though it must be said that courts have sometimes allowed their decision to be influenced by this consideration. In answer to the suggestion that the convenience of the public should be taken account of in determining the propriety of granting an injunction, Lord Selborne, L.C., replied, "It is said that the objection of the plaintiff to the laying of these pipes is an unneighbourly thing, and that his right is one of little or no value, and one which Parliament, if it were to deal with the question, might possibly disregard. What Parliament might do if it were to deal with the question, is, I apprehend, not a matter for our consideration now, as Parliament has not dealt with the question. Parliament is, no doubt, at liberty to take a higher view upon a balance struck between private interests and public interests than this court can take. In other words, so far as the utility to the public is made the basis of an argument, it would seem to be simply urging the propriety of taking private property for public use without the requisite condemnation proceedings, the unwise policy of which cannot be doubted. Assuming, then, that the only question before the court is the propriety of balancing the injury that may be caused to the parties by the decree, and remembering that the question does not arise except when equity has jurisdiction of the case because the plaintiff's legal remedy is inadequate, it should be noted that to deny the injunction is, 1. To allow the wrongdoer to compel innocent persons to sell their right at a valuation, and, 2. To refuse him altogether any equitable relief in a case where, on the ground of avoiding multiplicity of suits at least, he is clearly within one of the most frequently given reasons for assuming jurisdiction, and where, also, his injury may be irreparable. In view of this situation, it is clear that the plaintiff's prayer will not readily be denied, and it can safely be said that the argument based on the balance of injury to the defendant will be availing only in a limited class of cases. On the other hand, it is a general rule of equity not to exercise its extraordinary jurisdiction when it will operate inequitably and oppressively. The problem presented is, therefore, to strike a medium rule between these principles that, as fairly as may be, will do justice. The courts of Massachusetts and New York have considered the question, upon various states of facts, oftener than the courts of any other jurisdiction, and acting independently, have arrived at substantially the same result. That result, in the words of the Massachusetts court, is as follows, where, by an innocent mistake, erections have been placed a little up on the plaintiff's land, and the damage caused to the defendant by the removal of them would be greatly disproportionate to the injury of which the plaintiff complains, the court will not order their removal, but will leave the plaintiff to his remedy at law. The language of the New York court is, "It must be remembered that a willful trespasser cannot in this way acquire an inch of land, because the mandatory injunction must issue as to him, that in other cases where the injury to the plaintiff is irreparable the mandatory injunction will issue, and permanent damages will not be awarded, that where the granting of an injunction would work greater damage to an innocent defendant than the injury from which the plaintiff appraise relief, the injunction could be refused absolutely, and the plaintiff compelled to seek his remedy at law." In practice these rules are probably almost the same, and they perhaps represent as nearly a fair resultant of the arguments on the side of both parties as can be arrived at. Both rules protect the plaintiff from very serious injury, both deny any protection to a willful wrongdoer, and both, as far as possible, refuse to apply the remedy of mandatory injunction when to do so would be oppressive to the defendant. Doubtless they will be followed, though cases can be found which, not including the elements making necessary carefully qualified statements, contain broad dicta that the balance of injury will or will not be considered. It should be added by way of caution that the foregoing discussion applies only to the granting of permanent injunctions. It has already been pointed out that on an application for a temporary injunction, when the rights of the parties are undecided, the balance of injury is a controlling consideration. Section 1923. Section 509. Personal remedy open to plaintiff. In a number of cases a plaintiff has sought injunctions against trespasses when it would be possible for him by his own personal efforts to put an end to the trespass, and thus render the legal remedy adequate. In the leading case in which the question was considered, the defendant had covered a lot belonging to the plaintiff with large rocks, and in reply to the argument of counsel the court said, "It is now said that the remedy was at law, that the owner could have removed the stone and then recovered of the defendant for the expense incurred. But to what locality could the owner remove them? He could not put them in the street. The defendant presumably had no vacant lands of his own on which to throw the burden, and it would follow that the owner would be obliged to hire some vacant lot or place of deposit, become responsible for the rent, and advance the cost of men and machinery to effect the removal. If any adjudication can be found throwing such burden upon the owner, compelling him to do in advance for the owner what the latter is bound to do, I should very much doubt its authority. On the contrary, the law is the other way. And all the cases which give to the injured party successive actions for the continuance of the wrong are inconsistent with the idea that the injured party must once for all remove it. These arguments are not easy to meet, and there are cases in accord with its suggestion. On the other hand, there are cases in which the burden thrown upon the plaintiff in putting an end to the trespass himself would not be heavy, and in which, therefore, the injunction has been denied. If, however, the party whose land is trespassed upon wishes by his own efforts to remove the trespassing object, he may of course do so, and equity will not interfere with him. Section 1924. Section 510, Relief given. A brief paragraph may perhaps properly be given to noting the relief which equity gives in such cases of trespass as fall within its jurisdiction. It is, of course, clear that the only ground on which a case of trespass can be brought into equity is the plaintiff's right to an injunction, and this is therefore the primary relief given him. It is usually prohibitory, but only because prohibitory relief is more often desired. Despite occasional dicta to the contrary, the use of mandatory injunctions is well established. The discussion of the questions when equity will put a plaintiff in possession, and the effect of the balance of injury which will be caused by granting or withholding its relief, have made necessary previous citation in this chapter of numerous cases in which mandatory injunctions were issued. A few others are collected in the note, some of which the court went the length of decreeing not only the undoing of wrongful acts, but also the doing of rightful ones, not merely destructive, but constructive acts. Further, the general principle of equity to give full relief in a cause in which it has jurisdiction for any purpose applies in case of trespass as well as elsewhere. That it is under this rule that equity acts in passing on disputed titles has already been seen. On the same principle equity gives damages for past trespassing in addition to an injunction, but not when the injunction is refused for, want of jurisdiction or damages only may be given when the court has jurisdiction of the cause, but finds it necessary to refuse the injunction for some other reason than want of jurisdiction, as, for example, because an injunction would be futile. The flexibility of injunctions in the hands of the courts also enables them, by simply framing the decree in the alternative, to accomplish the purpose of condemnation proceedings in cases in which the defendant has the right of eminent domain, or to give permanent damages to the plaintiff in cases in which at law he could recover only the damages caused him up to the date of the suit. Section 1925. Section 511, Estoppel, laches, acquiescence. The general equitable rules as to estoppel, laches and acquiescence also apply in the subject of this chapter. No discussion of these rules will be undertaken here, as they are treated elsewhere. A few cases illustrating their application in cases of trespass are collected in the note.